respond to that's Canara Bank, my lord, Ernakulam. Wherein, my lord, I am on mainly on my lord territorial jurisdiction. The loan sanctioned, my lord, in the Ernakulam. The sale note is issued from my lord Ernakulam area. The property situated at my lord Ernakulam. All the parties situated, my lord, residing at my lord Ernakulam, not in Bangalore. Therefore, my lord, there is my lord this.
Why it is filed here then?
Please see, they can't file it here. That is my lord on the first and foremost submission before this. So either they have to go before the lord. Their assailed my lord sale notice issued by the Canara Bank, ARM, Ernakulam. At the most, my lord, they have to go before the DRT Ernakulam or my lord High Court at Kerala. Therefore, my lord, on first and foremost, my lord, they have to clarify the my lord territorial jurisdiction. Apart from that, there are so many other defendants in respect of sale notice, my lord, which I issued, my lord, to raise the sale. Report, my lord,
no, as far as the interim order is concerned, no, first submission I understand. You are saying with regard to the jurisdiction.
Please,
the second submission with regard to the whoever has issued this now the interim order if they are seeking the stay of the sale notice. So as far as that is concerned, only that's an interim order. So other respondents we will see. So now on the maintainability of this writ petition before this court, let him argue.
Please, my lord.
Yes, Mr. Counsel.
Yeah, my lord.
One more.
Let my friend complete. I don't want to interrupt him. Once my friend has completed, I will answer.
Very same counsel, my lord, earlier filed in a similar writ petition before this honorable court. The very same contention because Canara Bank head office in Bangalore, therefore, my lord, I am before this honorable court. This honorable court, my lord, not shown any intelligence. Then later they withdrew it. And my lord, that order also, my lord, I may permitted to my lord to this before this honorable court.
Yes, give that.
That's not a detailed order. They withdrew the petition in a similar set of facts. In that case, my lord, Chennai is obviously, my lord, DRT or High Court Chennai. But I just point out, my lord, the last paragraph, page number 4. The learned counsel, after arguing the matter for some time, seeks leave of this court, withdraw the petition, reserving liberty to the petitioner to approach the High Court of Tamil Nadu, because that is ARM Chennai. The submission placed on record, the petition according dismissed is withdrawn in the reserving the liberty to the petition sought for. I just point out, my lord, there, my lord, page number 2, Asset Recovery Management Branch, Coimbatore, and my lord, respondent number 1 is Board Directors of Canara Bank here. In here also, my lord, similar in nature.
Yes.
Yes, my lord. It's a fundamental principle of law that choice of forum is that of the plaintiff. The plaintiff is the dominus litus. He is the master of the proceedings. He is the carrier thereof. The choice it is, Supreme Court has said it, Ganga Bhai, forget about Supreme Court decision, fundamental principle of universal application. Choice of forum is that of the plaintiff, he being the dominus litus. And then when for the plaintiff being a dominant litus, in determining the choice of forum, he is not entirely free. He has to, there are other principles which are applicable, which concerning the determination of the choice of forum. That the principles are lex situs, if it is respect of a property, lex situs, where the property is situated. Lex res, that is where the respondent reside. Lex causae, where the cause of action has arisen. And in a given case, the cause of action may be in one place, the property may be in another place, and the respondent may reside in at another place. And then between the three concepts, lex res, lex causae, lex situs, the plaintiff as a dominus litus is free to elect any of the forums. Now, when it comes to Article 226 of the Constitution, there is a difference. Article 226 of the Constitution, may I take your ladyship may have Article 226?
Yes.
Article 226, yes.
Yes.
Article 2, may I read, my lord, ladyship, the Article 226. Notwithstanding, ladyship got it?
Yes.
Article 226.
Yes.
Notwithstanding anything in Article 32.
Yes.
Every High Court shall have powers. Every High Court shall have powers throughout the territories in relation to which it exercises jurisdiction. Towards the territories in relation to which it exercises jurisdiction. To issue to any person or authority, including in appropriate cases any government within those territorial territories, directions orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, or any of them, for the enforcement of any of the rights conferred by party and for any other purpose. The first respondent in this petition is the board of directors of the Canara Bank. I have consciously made the board of directors of the Canara Bank as a party to the petition because by virtue of the notification dated 29/5/2015 may take a leadership to page 94. Page 94 of the paper book. The responsibility for the constitution of committees, which is contemplated under the in terms of the notification, may take a leadership to paragraph para 2, page 95. Committees for stress, micro, leadership got it, page 95.
Yes.
Committees for stress, micro, small and medium enterprises. Subject to any regulation prescribed by the Reserve Bank of India for this framework, all banks shall constitute one or more committees at such a
You're arguing on the
location.
merits of the matter. You're
No,
arguing
I'm
on the
only on
merits of the
the
matter of the jurisdiction.
I'm only on the jurisdiction aspect now. My friend raised a
Yes.
question of jurisdiction.
Yes.
My
Yes,
friend said that yes, only on she said, my friend said the reputation is not maintainable for want of territorial jurisdiction. Subject to the regulation prescribed by the Reserve Bank of India for this framework, all banks shall constitute one or more committees at such locations as may be considered necessary by the board of directors of such bank to provide reasonable access to all eligible micro, small and medium enterprises which have availed of credit facility from such bank. So here the mandate, the notification is addressed to the board of directors of such bank. My grievance is the Canara Bank, the board of directors of the Canara Bank failed to discharge its statutory duty. Not a single committee was constituted. Forget about my case. Not a single committee was constituted from 2029/5/2015 till the judgment in the Pronis case and thereafter in the case of Sri Sami Samaf. That I get that is an admitted fact. And the Canara Bank said the same thing in a judgment of the Madras High Court at page leadership. I take your leadership to page yes, page 450. May I take your leadership to page 416? That is a judgment of the Madras High Court, Madurai bench. Leadership got it. A.K. Karthikeyan. Your leadership got it.
What is the
A.K.
page
Karthikeyan
number?
at page 416.
No, I think this entire petition, the pages are till 253.
Volume 2 is there.
Another volume is there.
I'm so sorry. Maybe it has been divided into 2 volumes.
Next volume.
Yeah.
So, 416.
Yes.
Page 416. This is the judgment of the Madras High Court, Madurai bench. A.K. Karthikeyan versus authorized officer Canara Bank. And may take your leadership to page number 432.
Yes.
Paragraph 11.
Yes.
In fact, the leadership got it. In fact, when a specific question was raised by the bench, whether the Canara Bank has formed any committee which is mandated under clause 2 of the framework for revival and rehabilitation of micro, small and medium enterprise dated 29/5/2015, it was submitted that no such committee was formed. This is my case only.
Yes.
Some other lawyer appeared because of my difficulty to travel to Madras. So to Madurai. It was submitted that no such committee was formed. Then coming again, my lord, leadership at page 443, 433 at page paragraph 12. Further, in the above clause 2, subclause 2, it is specifically stated that distressed micro, small and medium enterprise shall have access to the committee. When no such committee was formed, then the stressed MSMEs like that of the petitioners were deprived of any such opportunity to approach the committee. The bank is contending that the petitioner has not raised the issue of the benefits under the MSME scheme at the earliest point of time. When there is no committee, not a single committee has ever formed, not only Canara Bank, for that matter, not a single bank or financial institution in this country has ever constituted a committee. When there is no committee, then such plea of the bank cannot be entertained. And whenever that petition was allowed, directly take your leadership to paragraph 23 at page 443. For the reasons stated above, your leadership got it, page 443. Yes, para
Yes.
23. For the reasons stated above, status supra, this court is of the considered opinion that the petition is entitled to relief. Hence, the petitions are allowed accordingly, and the sale notices are set aside. Respondent bank is directed to formulate the revival and rehabilitation scheme of the petitioners unit under the notification dated 2015, and as revised from time to time, and the same shall be carried out as per the notification of 2015 and revised from time to time. Leadership, let me talk out of record for this notification since 2000, because I had a small role to play in the formulation of this notification, because I was representing some of the MSMEs. This notification was never given effect to. And initially when matters were taken up, then all those cases were all settled because the bank came forward and offered some OTS proposals. And then I also left the practice in the area of surfacing, etc. I started practicing mostly in Supreme Court. Thereafter, again, my lord, in 2019, I was banned from practicing in the Supreme Court for 1 year for raising the issue of the Kitangin practicing in the same court. It was a issue of Justice Farid Nariman practicing before this the Court of Justice in the Supreme Court. Then I had to come back to Bombay. And then I started again taking up the issue of the MSMEs. That is the background. So in this country, in all humility, it should not be taken as I am praising my own team. I'm the only lawyer who took up the issue of the MSMEs. And it is a matter of conviction, personal conviction, that this is the notification is the order of the parliament, reflecting the will of the people. And as a result of a consultative process which spanned over almost a decade from 2006 to 2015, where the Ministry of MSME, the Ministry of Finance, sorry, the Ministry of Banking, Department of Banking, the Indian Bankers Association, State Bank in particular, all MSMEs associations, all were involved with the process of resolution of distress. This is intended to help MSMEs so that they don't perish. It is no way against the bank's interests. And the committee constituted, this committee constituted is actually a committee by entirely at the hands of the bank. Out of the 4 members, 2 members are from the bank itself. 1 member, the subject expert, is nominated by the bank. And only an outside agency is representative from the.
Clarify the matter.
Yes,
Mr.
coming
Counsel,
back,
we are
coming
going to
back, coming.
I am only on the jurisdiction. Yes.
Yes, sorry, I deviated. Sorry, my apology. Now the all issue here is who was at fault. This repetition is founded on the premise that no committee was constituted, and the burden, the responsibility to constitute a committee is not on the branch manager. The notification mandates. I'm sorry, I'm again reading that paragraph. That the board of directors of such bank to provide, page 95. The board of directors of such banks to provide reasonable access to all eligible micros, etc., etc. So the responsibility to constitute a committee, which is of a judicial tribunal, sans any of the trappings of a court, is of the board of directors of the banks and financial institutions. And not a single committee was ever constituted. and the board of directors is at fault. The managing director is at fault. So the resolution has to come. These matters need to receive the attention of the board of directors. Tomorrow, under section 36 AA of the Reserve Bank of India, I can seek even the cancellation of the banking license to the Canara Bank, because when a statutory provision is so blatantly violated, some stringent action is contemplated. Nothing of the sort we have sought. We are protection of the note. All these steps in violation of notification be, and the committee be constituted. Resolution of stress. The bank and things are permitted. So, board of the bank is at Bangalore. Then protect you. Then my client said, okay, fine, they are protecting you. Then my client, okay, I didn't press it. It is when they call Canada, so we'll grant you. And that is, there is no law is laid on 2-line paragraph, which my issue. That what and fundamental principles of law application. So the difference in this difference, the Constitution article is the law as CPC all.
Yes.
Am I audible?
You're audible.
Yes. Oh, all right. Because it's my committee. Yes. Then all the issue 226, the territorial, the reason is the is emanate from the court. Court is what is chancery court, where the king is symbolically, and the has got our all within its territorial limits, or all subjects. Article 2 size is on the concept of where the respondent is lex reus. Respondent, the reus is respondent. Lex reus. 26 was amended in 1963. Ramara case, and cooperated. Leadership after the cause of action was incorporated. Page, sorry, article article 226(2). The power clause issue directions, orders or writs to any government or person exercise. So the power is to any government exercised by exercise in relation to territories within the cause of action or arises for the exercise of not the seat of such or authority or residence is not within territories. There, my lord, but for 220, no writ will lie before the Kerala High Court, because the board of directors has on the territorial limits of the Kerala High Court. So therefore, the concept of cause of action is a bundle which will thereof. The cause of action, the bundle of facts of if within the territorial limits of this court also as arising within the, so cause of action factor, and it only says in addition consideration of the residence of the respondent, the cause of action, they also can also be taken into account. And then in that sense, sustained to CPC may take a leadership to the CPC. Section 6. System CPC. Yes. Or 60. Yes. Section 16. Instituted sit-wait. That is the leadership concept of less situs. Not to tax your leadership's time. Of a more properly situated within the courts, any of the courts. Then, so place of institution sued by the decision of the courts are uncertain. And 19 suits for compensation of wrong movables. There the yes, whether then other suits or cause of action as a. So therefore these less res, less cause, less situs stand embodied in 20 of the CPC. And the Article 226 takes a slight difference, and the reason being 226 reincorporation of the section court, and therefore, in my humble paramount factor, determinative factor, right? Board of Directors, which has been tasked with the job of a committee, that's a core. Which since no committee was constituted, others failed. So the principal
Yes.
to the board of directors. So leadership subject to and then in all my array the first time for 43 years time. The this is an issue which was important, and the express provision of a benevolent without swords are crossed, hearing in the and why I say is some judgment, many of the judgments were to use a very soft language. It is weird. For instance, a repetition.
If your submission are completed, so that I'll pass an order.
Yeah, yes, then what I didn't 2 or 3 sentences. I was
No,
on that.
on jurisdiction.
Because on this issue, the Attorney General, the reason is the other day the additional Solicitor General said will be made a party. English jurisprudence. All cases are attorney public
In that
importance.
regard,
No. Let me complete. Let me complete it. No. Let me complete it. After that, you can reply. See, if I am all, then I complete my argument. The court decided. Yes, let me answer it. Yes, ma'am. Most of I have seen. I in my case, court decide whatever is the decision. Absolutely, I would say I never expected ever out of record. I say I have absolutely no problem. Let the court decide. They wanted to say that's all. They said there's a option. The Attorney General term proceedings, and in involving public, Attorney General could move the court. You will find Attorney General versus so and so, and so and so versus Attorney General. For any of the English books, for instance, Everest Stopper, the citation index will show there were so many versus so and so versus Attorney General is 3 part. Even where any question of law is involved, even assuming that nowhere the state is involved. For instance, a lawyer. It's a specific case. I don't exactly, the statement was passed. Then attorney was actually the issue concerning the reaction is a matter concerning public interest on a substantial. Therefore, Attorney General filed an appeal. So, Attorney General is the sole repository of public interest, and any question involving of a statutory instrument or independent involving any substantial question of law. And in addition to here in this case, of India as a party, the Ministry of MS is a necessary party. Yeah, there are 2 ways to do it. Every petition, that we follow that system from CPC or A of the CPC may take a order 27A of the CPC. 27A of the CPC. 20 of the leadership.
We have not gone to that stage now. We are not on the jurisdiction.
No. Yeah, I'm only on the issue. Only on the issue.
So that is
only
not,
on the issue of the.
That is not, I'm not on that now. If your arguments
briefly, what that I wanted to say here, the jurisdiction aspect is bad. In Kerala, or the branch is in Kerala, that only substantial question of law involved of Article 226, and particularly Article 226, 1 and 2. Therefore, Attorney General is on, and I take your leadership to of this 27 or this in my new books it's only 27 they shown 20 suits by yes 27 is suits involving is 27 law as in leadership has CP 27A. Suits involve interpretation constitution and before the government of India or as to the validity of instrument. Notice the Attorney General or in any suit to the court, any such question as is referred to in clause 1 of Article 132, 147 is involved, the court shall not proceed to determine the question until given to the if the question of law concerns the central government, the state, if the question of law concerns the state government. 1A, procedure in suits in of any statutory instrument in which it appears court that any validity of nature mentioned in Rule 1 is involved. not proceed to determine except after giving notice if authority with instrument. There is authority than the concern and other than the government. Not this shall not state. So notice is so I have made the attorney notice can I can be deleted from the party and I have no problem, but not attorney general. Even on the termination, and why I say so, I think in my more than years of practice, I have never done it. First time, make attorney and the party to proceed. The, the, the,
The presented petition is
can I,
filed. Extract the release from page number 50. The interim is sought as follows. The brief facts of the case.
Sanction is a sanction letter which
No. Genuine agro spices, a sole proprietorship engaged in the trading of, including export thereof, in 2011, and having ODM KL 02003223, Ministry of Micro Enterprises, Government of India. The company is situated at Optum Pivo. That the respondent number capital of rupees 28/2020. The respondent number 1 is the Board of Directors, Canara Bank, situated at Bangalore. Respondent is the Canara Bank, JC Road, and respondent number 3, officer and chief manager, Canara Bank, Panampalli branch, first floor, Parambi complex, Panampilya Nagar, overbridge, and they were fully secured by the collateral securities. That is A to F as A to E, as stated in paragraph number 4 of the petition, which are situated at Ernakulam district. In the 4 to 5 sanctioned credit facilities of 5 lakh, the sanction letter 2022. For the said loan facilities, the collateral securities are stated at 5, which are situated. The respondent 4 is Directors Limited, represented by its Managing Director and Chief Executive Officer, situated in Nagar. And the fifth respondent is Citibank of Kumbakonam, Tamil Nadu. The stated that 7 has also sanctioned the credit facilities of 3 crores, 6 crores, 8.35 crores and rupees 8. Facility letter dated 12/4/2021. For that, the mortgage created in Kerala. Respondent number 7 or Board of Directors of the Chennai. The 7 is authorized officer situated. Petitioner is a MSME. (2006). Section 9 and 10 of the said Act, read along with the notification. Framework for the promotion, development, and the Reserve Bank of India exercise of its powers under the banking banks in India to implement the Government of India MSME notification dated 29/5/2025, albeit by watering it down. Hence, they are seeking questioning challenging the provisions of the RBI notification that water down or restrict the provisions of the MSME notification dated 17/3/2026. In the writ petition, it is stated that the petitioner is constrained to invoke the jurisdiction of this court under Article 226 of the Constitution of India due to extraordinary circumstances. It is stated that in the present case, not only the High Court, but even the Supreme Court, instead of coming to the rescue of MSMEs, which are the backbone of India's economy, providing 60% of employment, 35% of GDP, and 45% of the exports, have given an interpretation to the notification dated 29/5/2015, which is contrary to the letter and spirit of the letter and spirit. It is stated that, and the petitioner has relied on several judgments and states that allowing the account to be declared as NPA and lost the challenge to recovery actions is contrary to the statutes and renders per incurium, and the interpretation needs to be reversed so that the justice can be done to the MSMPs. It is stated that when it comes to the cause of action, it is stated that the respondent number 2 and number 3 authorized officer arbitrarily declared the loan account of the petitioner as NPA on 27/6/2025 and issued the demand notice under Section 13(2) of the Surface Act on 1/7/2025 to the petitioner proprietorship, seeking repayment of an amount of rupees 12,50,60,266.01. And then the third respondent bank issued the possession notice dated 10/9/2025 under section 13(4) of the Act, taking the symbolic possession of the mortgaged properties. Further, respondent number 4 has issued a show cause notice dated 13/10/2025, directing the petitioner to show cause against classifying the first petition, classifying the petitioner as fraud, plaintiff's PAN card as fraudulent based on the internal audit report of on the petitioner's functioning dated it is stated that when the several judgments are discussed in the had stated so in the petition. The cause of action arises when the respondent 3 bank declare the loan account of the petitioner as NPA and issue the demand notice dated 1/7/2025 and further issued the possession notice and auction notices by the respondent banks. Questioning now the petition is filed. The cause of action for the petitioner to come before this court is the action of the respondent number 3 bank, that is, which is situated at Ernakulam. When the matter came up for hearing, learned counsel appearing for the petitioner, the respondent Canara Bank, respondent number
3, 1 to 3, but I am appearing on behalf of 3 now. I have instruction on behalf of
respondent number 3, Canara Bank, submits that the writ petition is not maintainable before this court, as the petitioner is questioning the action of the bank in declaring the account of the petitioner as NPA and issuing the demand notice under 13(2) and also a possession notice under section 13(4). It is submitted that the petition, the properties that are mortgaged to the bank are situated at Ernakulam. Loan was obtained at Ernakulam. And as the bank, the head office of the bank is situated at Bangalore, cannot be a cause of action for the petitioner to approach this court. And it is submitted that the writ petition has to be dismissed as not maintainable. Land counsel appearing for the petitioner submits that the writ petition is very much maintainable before this court. There are different cause of actions for the petitioner, and the petitioner, being the dominant litus, can file the petition before the forum which he chooses to do so. And there is no bar under Article 226 of the Constitution of India in filing the writ petition before this court. The learned counsel has referred to section 16 to 20 of the CPC and order 27 16 to 20 of the CPC and submits that there are different cause of actions in this case. But though the bank is situated, which has issued the loan as
Leadership, minor correction, leadership. What I said is the focus Article 226 is based on the territorial jurisdiction. The respondent, the head office of the board of directors of the Canara Bank and the chief executive of the Canara Bank. Let me say one second. Only one. They reside in Bangalore, within the territorial limits of this court. So Article 226 is territorial determined by territorial jurisdiction. So I am within the territorial limit. The bank of directors is before the territorial limits of this court. Therefore, the petition is maintainable.
Maintainable before this court. He has also submitted how the Attorney General is a proper and necessary party to this writ petition, as is questioning the judgments of the apex court, and also and also the procedure in which the borrower, MSME borrower, has been declared as the account of an MSME borrower is declared as an MSME.
Ladyship, one word of interruption. What I'm seeking that the judgments of the Supreme Court in Pronet and Sri Samasamat are rendered per incuriam and sub silentio. Therefore, it's a issue where the
A vital aspect of a question of law that is involved. The presence of the Attorney General is very much necessary. As such, he has made the Attorney General as a party respondent to this writ petition. It is submitted that he has relied on the judgment of the Madras High Court, where before the Madras High Court, the Canara Bank has stated that they have not constituted a committee as per the guidelines of the Reserve Bank and as per the provisions of the MSME Act. It is submitted that as this involves a question of law and the particular fact that there is non-compliance of the directions of the Reserve Bank and also the provisions of the MSME Act and the bank head office is situated within the territorial jurisdiction of this court in Bangalore. The writ petition as filed by the petitioner is very much maintainable. Next part. Having heard the learned counsel for the petitioner and the learned counsel appearing for the first respondent bank,
Third
respondent bank peruse the entire material on record. The undisputed facts in this case are petitioner had borrowed the loan from the third respondent bank, fifth respondent bank, and also the seventh respondent bank. And he has mortgaged the properties that are situated within the jurisdiction that are situated within the state of Kerala. The petitioner has raised several grounds with regard to the MSMEs and also the judgments of the Honorable Apex Court and how the the provisions and other judgments. The relief that he is seeking is that the proceedings that are initiated by the bank under Section 13.2, under Section 13.4 are bad, and the same have to be interfered by this court at an interim stage, and later at the stage of interim relief. The contentions with regard to that the cause of action is a bundle of fact, and it is for the petitioner to, being the dominant, he can approach the forum or as far as these submissions are concerned. The petitioner has reviled the loans from the banks at Chennai, from the banks situated at Kerala, and no doubt the Canara Bank head office is situated at Bangalore. For all the practical purposes, for the execution and for all other aspects, the major cause of action, that is the sanctioning of the loan, the mortgaging the properties that are situated at Kerala. The courts at Kerala have got the jurisdiction. Coming to the Bank of Canada, Canara Bank, that is the head office situated at Bangalore, that itself cannot be a ground for this court to say that this court has got the territorial jurisdiction to entertain the petition, to entertain the writ petition before this court. The petitioner as well could approach the bank. They could have approached the courts at Kerala and could have filed a writ petition. It is not that. If he files a petition before the Kerala High Court, that the Kerala High Court has no jurisdiction to issue notice to the Canara Bank head office, just because the Canara Bank head office is situated at Bangalore. The cause of action, the entire cause of action as stated, is as arising to the petitioner at Kerala, but it cannot be said that because the head office is situated at Bangalore, this court has got jurisdiction. Hence, this court is of the view that the writ petition is not maintainable before this court and accordingly dismissed, giving liberty to the petitioner to avail the appropriate remedy. Yes, Nick.
Your ladyship, one minute, your ladyship may stay the surface action enable me to either file an appeal or to approach the Kerala High Court.
No. Yes.
Your ladyship may record my submission and pass an order
Yes,
rejecting also no problem.
petitioner, while this court is dismissing the writ petition, when counsel for the petitioner makes a submission that this court may stall the proceedings for a limited period, giving an opportunity to the petitioner to avail the appropriate remedy. This court is not inclined to pass an order when this court is of the prima facie view that this court has no jurisdiction to entertain the petition. Question of passing any interim order will not arise. Yes, next.
Lordship,
14,
apologies, my Lordship.
Chikayu.
There are multiple objections due to urgency. I would move the matter, my Lord.